One more already for you. Next week कैसे है तुम्हारा?
Next week अभी सालों का दबा नहीं।
सालों। हमारे सेंट बाबा हम यहाँ पे टिकट
हमारे यहाँ चला गया Morning.
May it pleases your lordship. Item 22, my lord.
Yes.
We are going to file an IA on behalf of the state respondents, my lord,
22?
today. 22. Let the matter come up after a week, my lord, along with the IA. I have taken the consent of senior advocate, my lord.
As prayed for by M. Bormon, learned government advocate for the state respondent with consent from the petitioner, list this matter
after 1 week,
after 1 week to enable the state government to file their necessary return in the matter.
IA, my lord. Interlocutory application has been filed.
In the IA?
IA. We are going to file a IA for vacating, my lord.
To file necessary interlocutory application in the matter.
Another prayer, my lord, in respect of item 54, the hearing matter, my lord. One report has been called from the district judge Golaghat, my lord. I have checked the office note 85, my lord. That report has yet to come, my lord.
Have you taken consent from
yes,
the
other side? I have taken the consent.
Custodial death payment,
yes, my lord. An inquiry was caused by the Honorable High Court, my lord, and that report is yet to become, my lord. So let the matter.
Okay. In item 54, as prayed for by M. Bormon, learned government advocate for state respondent, with consent from the other side, list this matter next week on a date to be fixed by the registrar
after receipt of inquiry report
to enable the state government to place the report.
That report is called from the registry, my lord. It has to be submitted before the registry, so let it become after.
All right.
Not by us, my lord.
Cancel the entire order. Say that M. Bormon, learned government advocate for the state respondent, submits that the inquiry report called
from the district judge Golaghat.
From the
district judge Golaghat.
District judge Golaghat is yet to be received. Stop. List this matter after 2 weeks on a date to be fixed by the registry. Stop. However, before expiry of 2 weeks, if the aforesaid, if the inquiry report called for is received,
matter may be listed.
Registry may list this matter accordingly before the bench.
Obliged.
May it please the Lordship. Lordship, I beg to mention item number 18 and 33. Your Lordship,
18?
and 33. Can it be fixed at 2 p.m., Your Lordship? 18 and 30.
Why?
Your Lordship, I have some other engagement in other courts, Your Lordship.
All right.
18 and
18 and 33 at 2.
Lordship.
Have you informed other side?
Your Lordship, there is only the respondent, the state respondents.
May I please, Your Lordship? Regarding item 41, my lord, I am instructed to withdraw the matter, so I may be allowed to withdraw the matter. Item 41.
41.
41, man. Bill hearing.
AB.
AB.
Your name?
Mohibur Rahman.
Mr. M. Rahman, the counsel for the petitioner, submits that he has received instruction from the petitioner not to press the anticipatory bail application. Stop. Accordingly, he seeks withdrawal of the same. Next paragraph. In view of the aforesaid endorsement made by the learned counsel for the petitioner, the anticipatory bail application stands dismissed on withdrawal.
All right.
May I please, Your Lordship?
Yes, Mr. Gogoi.
Lordship, although there is an announcement, Lordship, apology, Lordship, I beg to make item number 6 mention, Lordship. It says, Lordship, all matter,
Wait for the turn.
Lordship, here,
Wait for the turn.
Lordship.
Yes.
My same prayer, Lordship,
Wait for your turn.
My reason will be because I am not be able to appear in this case, Lordship.
Ensure there is representation when the matter
Lord,
is called.
Lordship.
Yes.
May I please, Your Lordship? I beg to mention item number 35, my lord.
Item number?
35. My senior is out of station due to his mother's illness. Kindly may
35,
adjourn for the...
Mr. Das,
My lord.
CD is available. In item 35,
35, my lord.
30 is there.
and they are on interior.
Yes, on interior.
Let the matter be called. Next.
May I please, Lordship, I beg to mention item number 14.
Wait for your turn. Next.
So,
The
Lordship,
whole matter, wait for your turn. Yes, next matter.
May I please, Your Lordship? Lordship, I beg to mention item number 37.
30,
37. CD was called for. CD is not available.
37,
36 and 37 my lord, same case. The case there is not received, my lord.
36, same council.
36
No, my lord. I am not the same counsel.
He is not different
Are
consider.
you on interim?
Yes, my lord.
In item 30,
Both the matter.
then you inform 36 also.
Yes,
In
ma'am.
both
Yes,
the
ma'am.
cases, await CD, list this matter
On 30th of May,
on
30.
25/2024. Interim, if any, shall continue till the next date.
My lord.
37.
Please, my lord. I beg to mention item number 56 and 57, my lord. These matters are wrongly listed before Lordship, my lord.
56 and 57?
Here, my lord.
It is submitted on behalf of the petitioner
Right.
that the aforesaid matters have been wrongly listed before this bench. Stop. Let registry verify and do the needful.
My lord. May I please, Your Lordship? I beg to mention item number 11, my lord.
I remember
11.
for,
My lord, I want some accommodation.
yes, call the list. Be attentive when the announcements are made. Why are you unnecessarily wasting
Yes,
the
I
judicial
know.
time of this court? Just be there when the matter is called. This court will see. You will be accommodated. Yes, call the list.
May I please, Your Lord?
Yes.
My lord, in fact, my lord, today I have just now, my lord, received a copy of an affidavit in opposition to the IA, which I have filed for vacation of the interim
You are
order.
the applicant.
I am the applicant, my lord. A small rejoinder, I will file a week's time, my lord, may kindly accommodate.
In item number 1. Item 1 and 2 are
Yes,
connected.
yes, connected, my lord.
You are Mr. A. Bhattacharjee.
No, my lord, I am A.R. Bhuya, my lord.
Mr. A.R. Bhuya, learned counsel for the applicant,
My lord.
submits that he has received the copy of the affidavit in opposition in the connected IA
My lord.
few minutes back,
My
and
lord.
accordingly seeks accommodation for filing necessary reply if needed. Stop. Prayer is not opposed. List this matter
After a week, my lord.
after a week on a date to be fixed by the registrar.
My lord.
May I make a prayer?
This is interim. This is interim order. That may continue.
Interim, if any, shall continue till the next day.
I am appearing item number 2.
for the petitioner. They have filed the vacating application item number 1. Since the matters are connected, may all the matters be taken up for admission so that it can be
See on the
this would
next
have
slide.
ramifications to follow.
It's all right, Mr. Banik. Let it follow. You are having an interim in your favor right now.
My interim is vacated.
Anyway,
Oblige.
this is that Parthard matter. Yes.
Maybe. The last occasion, I was asked whether the learned tribunal below had exceeded the jurisdiction, whether it entered to decide upon the charge or not. That was the query. So, but may kindly have a look at the impugn order, page 244.
Page?
244. Starts from 244. Annex L. This is the interim
Yes.
order. And, now, this order, the second paragraph, it was the order shall dispose of the preliminary issue framed in this reference, which is read as whether the domestic inquiry held against the four workmen is valid and lawful. That was the issue before the tribunal. So now, on last occasion, my learned senior friend submitted that the tribunal below has exceeded its jurisdiction as it discussed and decided the charges. But here, one aspect he was raising that regarding representation, and another regarding maintaining of day-to-day office ordership. So day-to-day ordership on last occasion I submitted it is required. Otherwise, it cannot be ascertained on which date what happened. To get that day-to-day ordership is required. That is my reply.
Any authority to that effect?
That will not, nothing is clear. Now, what my learned friend submitted that the learned tribunal below entered into the charges and decided regarding
Where is the inquiry report?
inquiry report is not annexed below.
Do you have a copy?
No, I do not have the copy. They are not annexed in the repetition.
Mr. Datta, do you have a copy of
We have
the-
not annexed, Your Lordship.
But do you have?
No, not at this stage.
Because the inquiry report will also indeed, I think I had also pointed out on the last occasion.
Last occasion also.
That generally.
But that maintaining of the order sheet is out of the purview, Your Lordship.
No, I am not talking about the maintaining of an order sheet. But you see, when the proceeding is held, generally the minutes should indicate
Yes.
that on so and so date so and so has happened, on so and so date so and so has happened. Something is reflected in the proceedings of the inquiry officer. Now, generally, I have seen a proceeding
Yes.
is there.
Yes.
And there cannot be simply a report without there being any proceedings,
And
right?
it's 2 years long proceeding, Your Lordship. 2 years
No,
long.
be that as it may, but
Oh,
there
Lordship.
must be some
The Lordship's
records.
perusal, if Your Lordship directed us, we have to produce
I
it.
think since this point has come up, whether it is fatal, not fatal, that is subsequent. But since this point has come up, so perhaps it would be
Require for the perusal of the court.
better if you have the copy of the
Yeah,
proceeding.
absolutely. We'll place it.
Place it.
Let him finish, Your Lordship.
Then, Willard, if you will place it,
That is all right. You have made your point. You have argued, and this court has taken note of it. Now this
Miller.
court wants to satisfy.
So, Lordship, may kindly have a
on its
look.
own. You don't have anything else to do on that, isn't it? So you finish your arguments.
sure. So, Lordship, may kindly have a look at page 271. From here, although last occasion it was submitted that the inquiry office, learned tribunal below entered into the domain of merit, the 271,
Yes.
the second paragraph, I have scrutinized. I have scrutinized the evidence adduced by the parties, but I do not want to discuss more about their evidences in details as this order relates to the deciding of the preliminary issue only. I have gone to the search sheet. He has gone to the search sheet. I have gone to the search sheet issued by the management, which is a very lengthy one. The search sheet itself clears us that prior to the meeting incident on 6/7/07, some other incidents occurred in the year 2005-06 and up to 14/7/2007 have been included, disclosed in search number 4, 5 and 6 as charges against the workmen. I have meticulously gone through the enquiry report and found that, this is important, my lord, the enquiry officer himself observed that the management has not established the charges under clause 4, 5 and 6 of the search sheet. Thus, it is held by me that the charges number 4, 5 and 6 are very serious charges of misconduct. Such charges cannot be proved merely on probabilities and the evidence adduced cannot be perfunctory. In fact, the management has not adduced any kind of documentary or oral evidence during the process of domestic inquiry. As a result, failed to establish those 3 charges. On last occasion, so far my memory is concerned, that this second paragraph was placed before your lordship as if the learned tribunal below entered into the domain of charges and decided upon the charges. But the tribunal below has discussed the findings of enquiry officer, because in the preceding paragraph it is categorically stated the enquiry officer arrived into finding that charge number 4, 5 and 6 were not proved, and that has been reiterated by the tribunal below. Tribunal below did not enter into the merit of the case.
All right.
So, and subsequently, although the page 272,
Yes.
272
According to you, the tribunal did not enter into the merit of the
did not enter into the merit,
Alright.
because tribunal only discussed the findings of the enquiry officer.
to see whether the inquiry is valid or not valid.
Yes, enquiry officer decided that
Alright.
charge number 4, 5 and 6 were not proved.
Anything else?
That has been reiterated. So, this is regarding the entering into the charges, etc.
Very well.
Now, my lord, and the very first occasion, while this case was moved in a motion stage, Lordship, may kindly have a look at the order dated 30/10/2017. 30/10/2017, when the matter was stayed.
Yes.
Third paragraph, Lordship, may kindly have a look. The submission made by the petitioner. The judgment in Delhi Cloth and General Mills versus Ludbut Singh reported in such and such and Sur Enamel reported in such and such are read by the senior counsel to contend that the industrial tribunal misdirected itself in appreciating the domestic inquiry. Moreover, when the domestic inquiry was held to be vitiated, the management should have been called upon to adduce further evidence, but the presiding officer erroneously allowed the workmen to place further evidence in the matter. So, both parties were, but it is a fact, in light of direction in Ludbut Singh, management was supposed to ask to adduce evidence first on merit, then workmen.
No,
It was. But
it will be done in that fashion.
yes, my lord, that can be done. I do not have any objection regarding that. So their contention was not that they have challenged that preliminary award, only that part that they were supposed to ask to adduce evidence first.
This is not something which has been argued by Mr. Datta.
Yes.
Then why are you unnecessarily drawing the attention of the court to that order? Because you reply to what has been argued today.
Yes, madam. My reply regarding-
The petitioner can take a lot of points in their repetition. But
Logic.
at the end of the day, what matters is what has been argued before this court.
Logic.
So,
Final argument.
isn't it?
Yes, Lordship.
This you have not argued
No,
anything
no.
on that.
Only that argument was regarding inquiry tribunal below entered into the merit. That was the
We are only on the issue of jurisdictional error, Lordship. Nothing more.
that.
All right.
So now this, I think last occasion my senior friend referred Delhi Cloth, etc.
Delhi Cloth he has not referred.
I would not.
So in Delhi Cloth, it is stated that it is decided
No,
that
but in what context are you referring to the case of Delhi Cloth? Because the petitioner has not relied upon Delhi Cloth in the hearing of this case. Earlier they may have, but not during hearing. So are you relying on any particular paragraph of Delhi Cloth House?
yes, my lord. Regarding that, after holding the domestic inquiry as
Yes.
unfair,
The management has a choice.
Choice.
Correct?
Yes.
Now, suo moto, they will not be called upon
Yes.
to adduce evidence.
Yes.
They will have to, during at the stage when, before the decision of the validity, they will have to opt.
In
This
their
can be
documents,
done.
they have taken that stand.
So then,
They have taken
what
that
is the
stand.
relevance of Delhi Cloth House?
Now, this Cooper Engineering,
Yes, Cooper Engineer, they have tried to distinguish by saying there is a jurisdictional error.
jurisdiction. But here, my humble
You have
submission,
submitted, there is no
jurisdictional
very well
error.
Noted.
So,
Next.
as there is no jurisdictional error, the Cooper Engineering will be
restrictions
holding
in
the
Cooper
field.
engineers will continue.
Yes, Cooper Engineering will be holding the field. That's my submission.
Anything else?
No.
All right. Mr. I don't think any reply.
No, no reply.
But I'm going to post this matter on a day on which you will produce the proceedings of the inquiry.
Lordship.
And then I will close it ultimately.
Lordship may fix, even it's CFE, Lordship. We will, meanwhile, on Monday, Lordship may indicate we will place that report, Your Lordship.
Okay. Then say hearings concluded. List this matter on Monday, date to divorce, okay, on such and such date for enabling the petitioner to furnish a copy of the inquiry report along with the proceedings, along with the minutes of the
Lordship
proceedings.
may not list because that is only indicated. We will place it
No,
before.
it's all right. Let it be there. You
Lordship.
give it on Monday and then.
Yes.
Even if you're not there, Mr. Datta,
Yes,
the
you are
engineer
not-
will be here. You simply hand over whatever is available.
Only, Lordship, my presence if required. Because if your Lordship
I'm
dictating.
not using it on that day.
No.
I will close it after I receive the copy of the inquiry.
You will
Monday
save
will be
it.
only for placing that.
Correct.
Monday.
It will be saved, Your Lordship.
Yes. Anything, Mr. Datta?
May I indicate one thing only, Your Lordship? Already, if your Lordship holds that it is sent back to the labor court, the tribunal, to decide afresh, then I indicate that all the materials available before the labor court, because workman adduced evidence in respect of the preliminary issue, the inquiry officer also adduced evidence. All relevant documents were exhibited before the tribunal, Your Lordship. Only on the fresh decision may be taken.
No, if this court comes to a finding that the inquiry is valid, end of the matter.
Yes.
And if the court comes to a finding that inquiry is not valid,
Then only, Your Lordship,
the matter is
then only I only indicate.
at large before the labor court.
Yes, then only I indicate to refer the matter to decide under section 11A.
That reference is already made. They cannot travel beyond the scope of the reference.
Yes.
Reference is already
My only submission, all materials available before the labor court.
that the Firestone has already clarified
Yes,
what
yes.
are the available, what are the relevant records in terms of the amendment.
Yes.
Whatever is there, everything.
Yes.
Except the inquiry which is found.
Lordship, that I only indicate.
Nothing remains in this case. It is a RTA application has been made, but he hasn't preferred any appeal before the higher authorities. So straight away he has come to the court.
An application for information was made before RTI, and then Mr. Borwa, that was not.
Not adhered to. It was sent across to the
There is
second
an appeal
official.
provision, isn't it?
Yes, yes.
That was not.
No, he didn't prefer it.
Preferred. And item 4. None appears for the petitioner when the matter is called. Is present for the state government. Stop. It appears that on the last occasion, the matter was adjourned on the submission of the learned counsel to the petitioner. Stop. The matter relates to non-furnishing of information to the petitioner against the application preferred under the Right to Information Act 2005 through his application dated 15/7/2015. Stop. Which is the provision, Mr. Barwa, Mr. S. Borwal, learned
Section 7.
government advocate.
Section 7, I'm just clarifying one.
Have it. RTI Act for Dioxin.
Appeal. Second or third. First. Section 19 as I am.
Yes, have a look. And yes.
19.
Just give it. Mr. S. Borwa, in written, as well, and government advocate submits that Section 19 of the Right to Information Act 2005 provides appeal against non-furnishing of information sought under the said Act. Stop. He accordingly submits that the writ petition is not maintainable in terms of the efficacious remedy available in law. Stop. Alternative and efficacious. Heard? No, don't say heard. In view of the aforesaid appeal provision, comma, this court finds that the writ petition is not maintainable and as such dismisses the writ petition. Dismissed.
May I please, Lordship?
Yes.
Lordship, in the matter pertains to a tender work allotted to the petitioner for construction of a town committee building.
Anything survives?
Lordship, I have to. That's why I am going to mention it in the mention hour. Lordship, I need some time because for a considerable time I have no any contact with my client. And
This tender is relating to
construction of a town committee building, Lordship, of a kiosk town committee. Yes, he has completed more than 60% of the allotted work. Thereafter, the work was again taken back by the committee without paying anything. So yesterday evening, while I gone through the records, then I found that there is an IA filed by us for stay, which was rejected by this honourable court. This honourable court mentioned that there is a title suit pending for the same cause in the Jorhat court. So I have to take instruction whether the cause for petition will survive or not.
You are Mr. Borwa?
Borthakur, PP Borthakur.
Heard Mr. P.P. Borthakur, learned counsel for the petitioner. Stop. Also heard Mr. S. Borwa, learned government advocate for the state respondent. Stop. Mr. Borthakur, learned counsel for the petitioner, submits that there is a title suit pending before the court of
Jorhat.
Pending before the court of
Civil Judge Jorhat.
Civil Judge Jorhat pertaining to the same subject matter. Stop. Accordingly, he seeks some time to obtain instruction as regards the status of the aforesaid case before the learned court of Jorhat. List this matter next week.
I need to contact him.
Give a date
after 4 weeks, Lordship.
No.
No, actually, no contact. I have no contact number, Lordship.
You ensure you can always send a letter. You can find
I have to send letter, Lordship, that's why.
Give a date after 24th May. List on so day.
Oblige, Lordship.
May I please your Lordship? Lordship, earlier Counsel K. Gogoi was there in this matter, Lordship, but as he is representing government, Lordship, so he couldn't represent this case. And the other counsel is also no more, Lordship. So kindly 2 weeks time may give him so that...
Has any alternative arrangement been made?
Earlier also they have taken time like that, but I don't know why they haven't informed the concerned parties.
You see, you can't continue doing this. You 2025-319 order Mr. K. Gogoi, learned government advocate, prays that the matter may be adjourned as he will not be able to appear in this case any longer for the simple reason that he has now been appointed as government advocate. This is submitted March 2019, then January 2021, referring to the earlier order so-and-so and expressing his difficulty to appear in the matter. Mr. So-and-so submitted that the matter be posted after 3 weeks. Now we are in 24. Still you are making the same prayer. If you're not interested, we'll dismiss this petition.
Yes.
Why should this petition be continued unnecessarily? It's a 2016 matter. Have you informed the client or not?
Lordship, I'm not aware, Lordship.
Then this can't continue like this. Either you inform, and if the client is not interested in making alternative arrangements, then this court will dismiss this petition.
Lordship, kindly last chance may given or short date may fix, Lordship.
That's right. You are
N.N. Sharma.
MS so-and-so learned counsel appearing on behalf of Mr. K. Gogoi. 6. Accommodation in the matter as Mr. K. Gogoi is said to be unable to represent the petitioner in view of his engagement with the state government. Stop. Mr. A. Kalita, learned counsel for the respondent.
1 and 2.
1 and 2 draws the attention of the court to the orders passed on 25/3/2019 and 11/1/2021, on which dates similar prayers have been made. Stop. Next one. It is regrettable that since 2019, time has been sought in this matter on the ground that the engaged counsel is unable to appear on behalf of the petitioner as regards his present engagement with the state government. Stop. By now, alternative arrangements ought to have been made. Stop. Be that as it may, a last chance is given to the petitioner to intimate to the petitioner to make alternative arrangement in the matter, before the next date. List on, give a date next week. 16. List on 16/5/2024. Stop. Needless to clarify that if no alternative arrangement is made by the next date, this court shall take this matter, this court shall proceed with this matter in accordance with law.
Obliged.
Obliged.
Item number 7.
No, in this case, the relief as sought by the petitioner, they have obtained the relief, my lord.
You have already got the relief.
Yes, my lord, because the tower which was the
anyway, so then in fractious.
Yes, my lord.
Heard Mr. S. Khan, learned counsel for the petitioner. Stop. Also heard Mr. S. Borwa, learned government advocate for the state respondent. Stop. Mr. S. Khan, learned counsel for the petitioner, submits that the relief sought for has already been granted. Accordingly, he submits that the matter has become infractious. Stop. In view of the aforesaid endorsement made by the learned counsel of the petitioner, nothing survives in the matter for adjudication. Stop. Petition dismissed on infractions.
8 and 9.
Yes.
Maybe. My lord, in fact, this case based on a very short campus. It relates to, my lord, demarcation of the land.
Yes.
My lord, what has happened, very shortly stated, my lord. In fact, very briefly stated, what has happened, my lord.
Yes.
In fact, there is a subdivisional, my lord, land advisory committee of South Salmara who recommended, my lord, allotment of land to the petitioner. And accordingly,
you are supposed to file a rejoinder in this matter.
In fact, my lord, it rests on a, my lord, legal issue because the facts are almost, my lord, admitted. There is no dispute.
What is that you have prayed in this matter?
My lord, there are two matters. The second matter of 2015, the prayer is for demarcation.
15 is for demarcation.
Yes, my lord. And more or less, my lord, the second matter is same. But subsequently what had happened, certain materials were dumped, my lord, in that land, in my land. So there was an apprehension, my lord, that the state respondents, my lord, are proceeding to make some construction there. Therefore, in this, my lord, first case of 2016, Honorable Court directed status quo. So matter rested thus, my lord. Now here what has happened, my lord, very shortly stated, after issuance of the periodic annual patta, by virtue of a conversion case, it was converted to a periodic patta. And eventually, my lord, I applied for demarcation of the land. Now, suddenly, my lord, my periodic patta was cancelled. I challenged before this court. The court relegated back me to the appellate authority. And subsequently, the appellate authority, after hearing all the parties, they restored my periodic patta. Thereafter, my lord, I approached time and again, they please demarcate the land. Nothing was done. Not done. But now what appears, my lord, from the affidavit, that they say that a portion of my land is within the premise of the circle office. So perhaps, my lord, that is the reason for which, my lord, they have refused, my lord, for the demarcation. If that be so, my lord, this is absolutely illegal. Your lordship is aware there is an act, Acquisition and Requisition Act 1965, Assam Act. So under that act, the state government can notify to acquire the land.
Your land was not
notified. And if that be so, this is an illegal, my lord, grabbing of land. They cannot illegally possess my land.
Mr. Borua. How have you taken the land of the petitioner?
If I take your lordships to the affidavit, yes, if I take your lordships to the affidavit,
Because it is submitted that admittedly some portion of the petitioner's land is occupied by the circle office. Is it a correct fact?
that is, my lord, that has come out on the affidavit. If your lordship takes up the affidavit filed by the respondent file in the first matter, 195159/16,
yes,
I take your lordships to, my lord, the page number 3. This, my lord, it's a continuation of para, my lord, 4.
yes.
Yes, I read, my lord, 6 lines from the bottom, my lord.
That due
to inadvertent mistake on the part of the then employee of the Mankasa Revenue Circle to submit allotment proposal in favor of the petitioner, the government should not suffer. Further, this is relevant. It may be mentioned that at present the office building of the Circle Officer Mankasa Revenue Circle is situated over some portion of the land, as well as land is concerned, it's within the boundary of the Circle Office.
How some portion of the land is being occupied on what, by following what procedure or law?
In fact, if we go to the second continuing paragraph,
Yes.
The deponent stated is the fact that on 29/8/2005, annual patta was issued to the petitioner in respect of the land on the Mankasa town seat, number so and so, one katha, 2 lesser covered by so and so, dark number so and fixed total rent at ₹12, and the revenue over the annual patta was realized by the respondent on 30 from 2005 to 2009.
What does that mean?
So this is a revenue. The annual revenue has been realized from the petitioner's land. And if we, in fact, just in isolation, if we deal with this case, then definitely it might create some confusion. And so for that matter, 9 may also be taken into consideration. So in the 9, also our affidavit is very clear as regards what exactly has happened when they have approached the court, and there was a contempt matter also. And the contempt matter was also closed down.
What happened?
And the reasons being narrated very clearly.
The first and foremost, you answer to the query whether some portion of the land, as projected in your affidavit,
from the affidavit it
has
is clear.
been
Part of
occupied by the circle officer.
Yes.
If that is correct, then under what procedure of law the same has been done? Please clarify this first before we go to any other issues. Isn't it, Mr. Talukdar? This is what...
Exactly, my lord. In fact, your lordship is aware, Assam Land Requisition Acquisition Act 1964, more particularly section 3. The grounds, my lord, are enumerated on which, my lord, the notification can be issued.
If
Here, my lord,
do you have the information or not?
Yes, in fact, the affidavits are clear, but maybe today I may not be able to
Then
convince
you
your
get
lordship.
this information, we'll post it on Monday
My lord,
or
yes.
Tuesday.
Any day.
Sudeep, Monday, বেশি matters fix করা হয়েছে যে Tuesday দিকে. Tuesday better.
Precisely on this point, you will obtain the instruction.
It appears you give this order in 1959 or both together, but you put 1959 on the top. It appears from the affidavit in opposition filed on behalf of respondent number 5 in WPC 1959 of 2016 that the office building of the Circle Officer Mankachar Revenue Circle is situated over some portion of the land as well as the land, some portion of the land, subject land of the petitioner. Stop. However, there is no material indicating as under what procedure of law that the portion of the subject land belonging to the petitioner is being occupied by the Circle Office. Stop. Let specific instructions in this regard be furnished on the next date. Stop. List this matter on Tuesday, date to date.
Deeply
So and so. Mr. Borwa, just have this positive information. On top, you write SK Tendulkar for petitioner and Mr. N. Borwa for the state. Yes.
May I please elect? Petitioner is a resident of Sibsagar within the vicinity of David Hall, my lord. Is challenging the... No, my lord.
Lordship, in fact, I have not filed my affidavit, Lordship. The file was not with me. I have reconstructed it. Lordship will give me one opportunity. In 3 weeks, I will file it, Lordship. Deputy SG, Lordship.
Being not available, comma, reconstruction of the same is going on.
No, I have constructed
due to complete records not being available in the office, he has reconstructed the record and accordingly is going to file an affidavit in opposition in the matter. Stop. Prayer is not opposed by the petitioner. List this matter on, give a date after 2 weeks.
Let it be after 3 weeks, Lordship.
The old matter, Mr. Chaudhary.
I'll try my best, Lordship.
22nd May?
Fine, that's fine.
22nd May, so and so. Okay. You
Madam,
try to
yes,
make
yes,
an
I'll
effort.
try
It's a whole matter.
There is a status quo order, my lord.
Interim order, if any, shall continue till the next.
My lord. Obvious.
May I please, Your Lordship? My lord, this is regarding, my lord, enhanced compensation, my lord. The land was acquired, my lord, for the purpose of permanent protection by construction of an embankment. In the year, my lord, 2000-2001, my lord, the land possession thereof
Affidavits have been filed.
filed, my lord.
BDC has filed it.
No, on the last order it appears some instructions were required. Those instructions have been placed.
No.
The last order is 17/11/21.
Lordship. No, that's not received. That's not received.
You are appearing for whom, Mr. Goswami?
Deputy Commissioner.
He is respondent number?
The respondent, Lordship. 13, Lordship.
Because it appears that
6.
2 affidavits have been already filed.
Lordship.
But after filing those affidavits also there is an order of 17/11/21.
Yes, Lordship. Lordship.
You have a copy of that order?
Yes, Lordship.
Because as per that order, it appears that Mr. Hendik had submitted that although instructions has been sought, same has not been received. And he was directed that specific instructions as to when the acquisition was made and the award passed.
Yes. That's not received.
You have not
No,
received?
no, that's not received. Yes, ma'am.
When can you have this instruction?
10 days, Lordship.
But have it positively because
It is an old matter, so I'm
it's a
sorry.
very old matter and this order is of 21.
Yes, yes. Sorry, Lordship.
Mr. N. Goswami, learned government advocate Assam, submits that the instructions sought in terms of the order dated 17/11/2021 shall be positively placed before this court within a period of
10 days.
10 days from today. Stop. In view of the aforesaid assurance made by the learned government advocate, post this matter on such and such date. 1 week or 10 days of the date.
Published.
What is this matter?
In this case, there is ethnic violence lawsuit. Some person killed by the police lawsuit. They are seeking some
Special Magistrate Inquiry,
Yes,
CBI.
CBI.
Into fake encounter.
Lawsuit. And we have filed an affidavit. We have also
And
enclosed
what
some.
is this Parawise comment which has been directly sent to this court by the Deputy Secretary, 21st June 18? Who is appearing for the Deputy Secretary to the Government of Assam Personnel Department?
We are paying.
You are paying?
Okay.
You are saying you have already filed the affidavit?
Lots, lots.
Sorry, Madam.
You are appearing for the petitioner?
Yes, Madam.
What happened to the notice to respondent number 12? It has been served?
Yes, Madam. Already served, Madam. As per Lozima court order, Madam. There is order, Madam. Accordingly, in the earlier occasion,
Yes.
observed in the order, Madam.
What is your case?
Yes, my lord, 2 persons killed by the police personnel, my lord. My lord, the FIR, my lord, and the FIR was lost by the police, my lord, page 22, my lord.
You are seeking a certiorari for setting aside the inquiry report.
Yes, my lord.
There has already been inquiry report.
Yes, my lord.
What happened in that inquiry report? What
Because-
has been held?
Because, my lord, the inquiry report, my lord, supported the police, my lord. My lord, the actual FIR.
According to inquiry, there has been no fake encounters as alleged.
Yes,
Correct?
my lord.
Where is your stand in the affidavit, Mr. Goswami?
And the, my lord, inquiry report submitted by the executive magistrate and the report submitted by the police are contradictory, my lord.
Report of
Police and the report of the executive magistrate.
where is which page do you find report of the police?
My lord, police, my lord, page 16 of the affidavit filed by the respondent number 6, my lord.
And EM?
And the EM, my lord, page 42, my lord, of my writ petition.
42.
Yes, my lord.
Yes,
Yeah.
come
And-
to page 42.
Page 42, my lord.
Yes, read.
With reference to the above, I have the honor to submit herewith magistrate inquiry report on the date of Ramzan Ali, so-and-so, and Shahar Ali, so-and-so, 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 who is the said person got killed in police firing. Then brief of the case, my lord. As per information received from police on 24/7/2012 at about 9, this is very important, my lord, 9:15 a.m. This is very important time. A huge group of Muslim miscreants armed with guns and other lethal weapons attacked the borough population at village Bamungao under Kokrajhar PS. The group of miscreants were setting the houses on fire. After receiving the information, Sri Anjan Pandit, Deputy Superintendent of Police P. Kokrajhar PS, District so-and-so, with SI Rishikesh Hazarika and his party, immediately rushed to the PO. When the police party arrived at the PO, suddenly the miscreant attacked on police party with a view to snatching arms and got property.
executing the right of private defense, and in order to protect the village from the attack of the miscreant, police also resorted to controlled firing to dispense the move. As a result, two unidentified Muslim youths received bullet injuries on their persons. Immediately, both the injured youths were evacuated.
Page 45 is the finding.
Yes, my lord.
Page
Page 45 finding, my lord. But
the finding is that the statement recorded indicates that the police party had to open fire in self-defense. Correct?
Yes, Lordship.
And in order to disperse the mob who were destroying the houses of the villages.
And last two lines,
Now,
it is also evident from the statement recorded above
Yes, I've
that the
read it.
police party had to open fire only.
Yes, I've already said.
And my lord,
Now come to the page 16 of the affidavit.
my lord, for a moment, my lord, time, my lord. Time is very crucial, my lord. 24/7/2012 at 9:15 a.m. Then, my lord, my lord, firing was conducted in pursuance of the order given by the Bipul Bosho, my lord, circle officer, my lord, reflected at page 44. My lord, but regarding his statement, my lord, nowhere is mentioned, my lord.
All right.
Whether,
Now come to page 16.
and my lord, another thing, my lord, estate of the village Bamungao, page 44, my lord. What is stated, my lord? Serial number C, my lord, statement of Nilkamal Bosmutari, Sohan Bosmutari. In his statement, he has stated that 1/24/7/2013, and in the police said, my lord, 24/7/2012.
There will be technical error, Lordship.
Maybe 12/13, maybe there is a technical error, my lord. A huge of violent Muslim people armed with guns and other lethal weapons attacked the village in the forenoon. And police stated, my lord, 9:15 a.m. And the villagers, my lord, statement, my lord, on forenoon. And started setting fire on the house of the mob village of village so-and-so. My lord, then another statement, my lord, of the villagers.
So next para, Lordship. Next para, Lordship. He stated that at about 3 p.m. a police party arrived at the village while the mob was still present, Lordship.
Yes.
So it appears that there was a mob
Yes.
which was becoming unruly,
Yes.
and in order to protect, the firing was done. This is what.
As per a statement, my lord, of police, my lord, 9:15.
That's all right.
And the villagers, my lord,
you see that
forenoon
there
and
could be
afternoon.
something here and there. Now you come to that other lecture, page 16.
Page 16.
This is the inquiry done by the SP Kokrajhar.
No, my lord, by Inspector G.K. Kolita, C.I. Basugao. My lord, in 16 operative.
Here also it is the same finding, Mr. Goswami, isn't it?
Lordship.
At page 60, running page 63, it appears in order to
Finding?
save life and property and executing
Yes,
the
yes.
right of self-defense, police party started firing.
Yes. This is finding is same, but in the statement recorded in between, my lord, page 17, my lord. Page 17. Paragraph 2, my lord. During investigation, IO SI Deep Nursery of Kokrajhar PS visited the PO and drawn up a sketch map of the PO and indexes. IO found no arms and ammunition, empty fire cache from the PO as the unruly mob escaped from the communal ethnic violence which was occurred on 24/7/2012. And there is no any seizure list, my lord. The FIR lost by the deputy superintendent of police, my
What
lord.
has happened after the report?
Lordship.
And,
What has
my,
happened? It
and,
has been closed.
Lordship. Yes.
and there is no, my lord, any seizure list, my lord, as stated by the police himself, my lord, in the report, my lord, page 17.
Which is the affidavit, Mr. Goswami, that you are relying of
That is-
R6 or R2?
That is filed by R6.
R6.
Rajan Singh. Yes.
page 17, my lord.
1 second.
Page 17.
You have filed a reply affidavit to the affidavit in opposition filed by R6.
Yes, my lord.
Where have you, what is the reply to paragraph 10?
Paragraph 10.
Paragraph 10, paragraph 13.
Paragraph 10. I have stated in page 2, paragraph 6, my lord.
1 second. Your reply, yes, I have. This is dated 27 February.
Yes, my lord. 27th of February.
Which para?
Paragraph 6, my lord. Against paragraph 10.
Yes.
And paragraph
Yes.
8 against.
Read.
That the deponent denies the statement made in paragraph 10 of the affidavit in opposition and begs to reiterate the affirmations made in paragraph 11 of the writ petition. And further begs to state that the respondent number 12 has not conducted the inquiry properly to find out the real facts and truth in this matter. Sir, your lordship, so and so, so and so. And against paragraph 13, my lord, I have stated in paragraph 8, my lord, page 3. And I have to reiterated the, my lord, paragraph 11 of the writ petition.
Indefinite curfew was there, Lord.
All right.
And against paragraph 13, my lord, I have stated in paragraph 8, my lord. In the affidavit, my lord, page 3. Reply.
Anything else?
And my lord, the FIR lost by the police, my lord, stating, my lord, the move entered with weapons, my lord. But there is no any seizure list as replied by the police in RTI, as well as the report submitted by the police also, my lord. In the affidavit also it is clarified, my lord, there is no any seizure list, my lord.
All right.
And my lord, our case is, my lord, the postmortem reveals, my lord, there is cut injury also, my lord. And we assume that, my lord, our presumption is that, my lord, the police arrested them and tortured, thereafter killed by firing, my lord. My lord, the
This is the magistrate inquiry, Lord. Lord. No. Based on my knowledge, no, Lord. Lord. It is where the police lodging. It is the investigation report.
That is the investigation
Lot,
report.
lot.
That was submitted when?
Submitted. It is not there, Lord.
In the year
Date is not there?
2016.
Huh?
2016, 16 or 14, my lord. At page 18, below signature, my lord. 14, maybe 14. April 2014, maybe. Not clear. My lord, for a moment, kindly.
So, what is the date of that report?
Date of my lord?
That report.
Report, my lord.
The report submitted by Inspector G.K. Kalita.
Yes.
What is that report dated?
In the year 2014, my lord, page 18. In between in signature. 14.
Page?
Page 18 of the affidavit. Below signature, my lord. They have no. But not visible, my lord.
No, there is no date. It's absolutely not visible. This was done by the police immediately after the incident, Mr. Goswami.
Not it.
And after this, a magistrate inquiry was conducted.
Yes, yes.
That magistrate inquiry is put to challenge.
Yes.
What are your grounds for challenge?
Yes.
It appears to that you're trying to bring out a case that there has been some contradiction as regards the recording of the data and all. But no serious otherwise there, because it appears that the magistrate inquiry was based on evidences.
Yes,
Statements have been taken. Based on those statements, the report has been submitted. How can this court now sit and appeal against those inquiry?
Because, my lord,
There is nothing illegality
My lord,
manifestly that you have pointed out which warrants a CBI inquiry or anything.
my lord, FIR reveals, my lord, on 9:15 a.m. But the statement of the villagers, my lord, forenoon and afternoon.
That is true, Lord. Yes.
About yes, my
the
lord.
gist of the incident is admitted. It appears that you all have come.
And our case is, my lord,
those two
actually-
persons had come armed with, and that too during curfew.
And actually, and our case is, my lord, both the person missing, my lord. Accordingly, we have lost the missing case, my lord, before the concerned PS, my lord, PS 18. Subsequently, we got information, my lord.
Yes.
PS 18 of my writ petition, my lord. In respect of Ramzan Ali, my lord. FIR lost on 27/7.
They lost the statement what my lord. Like he did not read the second paragraph, Lord. He did the first paragraph. Second paragraph is something clearly mentioned, Lord. That is 12 of our affidavit, Lord. That is statement of villagers of Bamungao, statement of Nilkamal Basumatari.
Yes.
Second paragraph. He stated that at about 3 p.m. a police party arrived at the village while the mob was still present at the village.
Page 12.
Yes. Yes. The statement of Nilkamal Basumatari, second paragraph, Lordship. A police party arrived at the place while the mob was still present at the village. Right.
But the first paragraph, my lord, a huge, my lord, and there is a procedure, my lord, for encounter, my lord, which was prescribed by the Honorable Supreme Court. There is a actually, actually, my lord,
no. Lodge.
No.
No, Lord.
Yes.
My knowledge.
Yes, police report itself revealed, my lord. Police had to open fire only, my lord. Not to fire directly, my lord. It is revealed, my lord. On the other hand, if police did... Yes, my lord, there is a guideline framed by the Honorable Supreme Court. Paragraph 13, 24 and 31 is the finding.
Encounter.
Yes. Paragraph 31 is the finding. My lord. 31, my lord.
Yes. Yes, read.
In the light of the above discussion and having regard to the direction issued by the Bombay High Court, guideline issued by NHRC, suggestion of the appellant, PUCL, MK Superior, and the affidavit filed by the Union of India, the state governments, and the Union territories, we think it appropriate to issue the following requirements to be followed in the matter of investigation: police encounters in the case of death as the standard procedure for thorough, effective, and independent investigation. Then, my lord, 31(1). Whenever the police is in receipt.
Two estimate.
14.5. Oh, bless. Yes, my lord, I will find.
Item number 13.
Yes. Who is appearing in 13? None appears for the petitioner when the matter is. Yes, you are appearing, Mr. Dhanuka? 13.
Lordship, matter will be taken after some time, Lordship. Ordered 2, Lordship. After some time, Lordship. Ordered 2, Lordship.
Yes. After some time.
Item 14.
May I please, Your Lordship?
Yes.
Lordship, as per order dated 1/9/2022.
Have you filed your rejoinder?
Lordship, not yet. Lordship, we could not collect all the papers. Only up to 16th we have received a copy of the balance sheet, and yet to receive the valuation report from other visitors. Only 4 have been received.
So you want some more time?
Lordship, at least 3 weeks time.
What to do, Lordship?
But that rejoinder perhaps would
be necessary.
How much more time would you require?
Lordship, at least 1 month, Lordship.
No. 1 month.
Lordship, the last report will come from Delhi, Lordship. That is the valuation report from the
Be
Delhi.
reasonable. This is the 2019 matter. 2 weeks at best.
Lordship, it will, and the persons who will sign the affidavit now is presently at Pondicchery, Lordship.
You
They
do
will be coming
whatever
on
is
first
to be
April.
done. That is your problem, Mr. Counsel. This is a 2019 matter.
Lordship, at least 3 weeks time may be given, Lordship. We will try our best.
3 weeks, Mr. Jordan? Yes. Mr. Your name?
K. is Kondokar.
Mr. So-and-so, learned counsel for the petitioner submits that despite efforts to collect the
valuation report
and
balance sheet
in order to file the rejoinder affidavit, the same could not be done. Accordingly, he seeks 4 weeks time for filing the rejoinder. Stop. Prayer is opposed by M. Hajorika, learned senior counsel, assisted by Mr. So-and-so. Considering that the rejoinder is essential for final for effective adjudication of the matter, as a last chance, 3 weeks time is granted to the petitioner to file the rejoinder. Yes. Stop. List this matter. You want a date, Ms. Hajorika?
Yes, I think that's better.
A date after 3 weeks. List on such and such date. All right.
Here in this case, my lord, we submitted a representation, my lord, before the authority, my lord, deputy commissioner, to obtain our caste certificate, because our forefathers were all SC, belongs to the SC community, my lord. And representation has been already, my lord, submitted, and but that is communicated, my lord, to the, my lord, circle officer, and circle officer also, my lord, submitted some part of the report, my lord. So
no
at this
affidavits have been filed till now.
No, page 28, my lord.
In Lordship file, there is a procedure how to apply
certificate lordship. They have to apply online lordship. They have not applied so far online.
Application has not been made in terms of.
Lord, that is there. I have seen
Where
in
page?
the lordship file. There is a notification I have seen. Lordship.
Where is that?
Notification is there. Lordship.
This is item
15.
It is 16 December. 15 to date. 15 date. 2263.
Because, my lord, if it is...
One second, the wrong file has been given. Just one second.
The second file.
May it please your lordship.
Yes, my lord. Yes, it pertains to allotment 1 San Mahal.
Lordship, kindly some time may be granted. Lordship will obtain. Lordship will obtain instruction as if it has been retendered or not. Lordship, we have to obtain that instruction as well as we have to file affidavit. Lordship.
Yes, yes, ma'am.
Lordship. Lordship, last chance may be granted. Lordship, I'll file the affidavit.
The verbal submission. Verbal. In the meantime, if they wish, they can file affidavit as well. And in the meantime, so we had a prayer for interim, since they were making preparation for cancellation or something. Yes, yes. This is for
S. Kemprai, Lordship. Yes, Lordship. Lordship. 3 weeks time, Lordship.
relocation.
Return.
If any date may be fixed when there is a long pending case,
Obliged.
will become infractual other day. Okay.
Online application file matter because our fathers are belongs to OBC matter. Our forefathers are SC matter. That's it.
No.
Yes. No, my lord, we cannot, my lord, because our fathers were also, my lord, belongs to the OBC category, my lord. But our forefathers were, that's why.
Yes, Lord.
That option is there, my lord. In Seva City also, my lord. So, my lord, my representation may be, my lord, considered, my lord. Annexure, my lord, 5, page 28.
Lordship. Yes, Lordship.
That
direction may be well, Lord.
That direction may be given, my lord.
You will apply, Lordship, on that procedure?
Yes, my lord. As per this notification, we will apply
No,
for.
no.
Giving that, my lord, observation, your lordship may dispose. Giving that, we will apply for, my lord, in accordance with law, it may be considered as per notification. Again, we can, my lord, if it is rejected. My lord.
though the petitioner's grandfathers have waived their reservation rights in the year 1951 NRC by marking X, capital X within quotes, in the caste column, comma, yet the petitioners belonging to the scheduled caste category, comma, cannot be deprived of their recognition. Stop.
Petition, they have valid documents of land also to establish their caste.
Before entering into the merit of the case, comma, pertinent that Mr. N. Goswami, learned government advocate, draws the attention of this court to the office memorandum dated 8/8/2022, whereby guidelines has been prescribed for issuance of scheduled caste, scheduled tribes and other backward classes, more other backward classes certificates. Stop. He further submits that application has to be submitted in the requisite form prescribed in the aforesaid office memorandum in order for issuance of scheduled caste certificate. Stop. Next para. Admittedly, in the present case, no such application under the office memorandum dated 8/8/2022 has been submitted. Stop. That being so, comma, this court is of the considered view that this writ petition can be disposed of with a direction to the petitioner to file the requisite application in the prescribed form in terms of the office memorandum dated 8 August 2022, and as and when such application is being filed, comma, the concerned respondent authorities shall dispose of the said application in accordance with law. Stop. Needless to clarify that the said exercise shall be completed within a period of 45 days from the date of receipt of such application. Stop. With the aforesaid observation and direction, this writ petition stands disposed of.
All right, Madam.
May I please, Your Lordship?
Yes.
Lordship, another writ petition, Lordship, where the issue involved is same. Lordship, there is another writ petition which is pending, Lordship.
This is electrocution debt?
Electrocution debt.
Mr. Deka, you are appearing for the APDC?
APDC.
Electrical engineer report is
Is
available?
that? It is
that
that.
against you?
No.
So admittedly there is no negligence on behalf of APDCL? Yes, then?
Then, Lordship, there are
Item 19 and 20.
Yes.
Ownership right, as a right he can apply, my lord. And the petitioners were under the impression, my lord, because all the three are brothers, my lord. So the right in ownership right will be acquired by on behalf of all of them, my lord. But my lord, subsequently, when this land was acquired by the government, my lord, they came to know that he has got the ownership right only his own name, my lord. And accordingly, my lord, the compensation they were not paid the compensation, my lord. Then they filed objection before the deputy commissioner and district commissioner, my lord, also that they say that no, their name is not there. So then he approached the honorable court, my lord. Now, my lord,
so there is a dispute.
The dispute, my lord, the private respondent filed affidavit, my lord. They say, my lord, that this plot of land is not the commonly cultivated by them, my lord. This was a separate plot of land, my lord. It in there, but my lord, our stand is, my lord, that no, this is not factually correct, my lord. So we also file a representation before the district commissioner, my lord. So my lord, all the records are before the district commissioner, my lord. So if district commissioner is directed to, my lord, pass necessary order on the representation, that can, I think, my lord.
Yes, that can be done, because so far as our stand, my lord, that the particular plot of land where our names were muted, my lord, he has no connection with this. Accordingly, that has been done. Now, if there is any dispute, my lord, all
Who is
record.
appearing for the district commissioner, Ms. Borwa?
Because, my lord, if this land was, my lord, commonly cultivated, then that also maybe
So
on record.
the
my lord.
basic controversy is whether the petitioner are entitled to the compensation or not. Now, there is a dispute as whether it is commonly cultivated or not. That is the dispute.
Yes, my lord. And my lord, whether the possession was petitioner have the
But these
possession.
are the issues which has to be finally decided.
My lord.
How can the DC decide?
My lord, because, my lord, when the possession was taken from the petitioner, my lord.
Where is the representation?
Representation, my lord, is page 73 of my additional affidavit, my lord.
20?
73, my lord. Page
73.
73, my lord. Additional affidavit.
Yes.
Item 19.
All right, let this representation be decided.
Yes, no problem. My lord, so far as item number 20 is concerned,
yes.
20 is, I appear for the respond number 4, my lord. And I have a title, my lord, over well, and I am the awardee also. The compensation has not been released because of the pendency of the petition.
Then in that also there is a
Similar,
representation.
yes, my lord. My lord, in this case.
I think then in that case, this court can direct that let that representation be considered after hearing all the stakeholders.
Yes.
So you all appear before the DC and submit your respective claims. Let the DC take a call in accordance with law. Is that all right, Ms. Borwa? That can be done. 4972 and 4793, 19 and 20. Heard Mr. G.C. God, learned counsel for the for the petitioner. Stop. Also heard.
This is respondent number 456 A. Chaudhary, my lord.
Mr.
A. Chaudhary.
Mr. A.U. Chaudhary, Learned Counsel for respondent number 4, 5 and 6 in WPC 4972 of 2022 and MS
B. Chaudhary.
And MS B. Chaudhary for respondent number 4 in WPC 4793 of 2022 along with MS S. Borwal, Learned Government Advocate for the state respondents, and anybody else? And MS C. Hazarika C. G. Hazarika for respondent number 1. Stop. In the efforts in the present two petitions, the petitioner is assailing non-payment of compensation to the petitioners stroke owners of the subject land which was acquired under section 6(1) of the Assam Land within bracket Requisition and Acquisition Act 1964. Stop. The case of the petitioners is that they are of village Pup Majri Gao, PS Ajara, PO Bhatapara, Guwahati as riots stroke tenants since long time. It is submitted that a representation has been filed before the district commissioner Kamrup as regards the payment of compensation against the subject land of the petitioners, which is still not being attended to. Stop. It further appears that there is some dispute as regards the entitlement of the compensation as regards the subject land between the owners of the land. Stop. Today, when the matter was called, there has been a consensus amongst the parties that this writ petition can be disposed of with a direction to the district commissioner to dispose of the representation filed by the petitioners after hearing all the concerned parties within a reasonable period of time. Stop. Next one. In view of the aforesaid concession made by the parties, this court disposes of this writ petitions with a direction to the district commissioner to dispose of the representation dated 18/1/2024, and in the other case,
same date,
18/1/2024, filed by the petitioners after hearing all the concerned parties, including the private respondents, within a period of 2 months.
Malik.
With
All right,
the aforesaid observation direction, the petition stands disposed of.
all right. Oblige.
I shall just resume in 5 minutes.
So here on this sale notice was issued, I have deposited the entire money. Sale certificate or page 41 is the sale certificate. Kindly see. Page 41.
Page 41.
Page 41.
Yes.
So this is the sale certificate.
Who's appearing for the other side?
Bank is representing Mr. Das. So now till today they could not hand over.
MS Das.
As Das.
Huh?
Das.
Not there today. It is, I think, H. Das or S. Das. Additional senior government advocate was appearing in this matter.
No.
No, in the order sheet it indicates H. Das, additional senior government advocate for Assam, is appearing. Anyway, are you all appearing in this matter? This is 634, item 21. Is there any confusion?
So already we have deposited the money, but position is not yet handed over. They could not hand over the position.
But concerned will be the bank authority.
Bank authority,
Lord
Bank
CBI.
authority.
So they are not here today.
Lot.
Shall we
Let it be Monday.
release this on Monday? In the meantime, you inform them. Inform the council for the bank. Okay.
Monday.
Monday may be difficult.
but-
Wednesday.
Wednesday, my difficulty is there. Wednesday, my difficulty.
Tuesday?
Tuesday can be. H. Rahman.
Item 23.
Your Lordship, my senior is in courtroom number 1. Please pass the matter. Please pass the matter for the time being. Please.
My lord, here, my lord. Affidavit I have filed, my lord. I have filed the affidavit. Yes, it has been filed. My lord. On 20th of March 2023, my lord. On my lord, 23rd of March 2023.
Lordship, Dr. A. Todi.
My lordship.
Between date to session, Purnima display. My lord, it is 20. 20, not 23. 20 March. 20th of March. 20. 23, 24, yes, sir. Short issue, my lord, next week, my lord, if possible. Much only.
Item 24.
But my friend was to take instructions in the
Well, here, my lord, on Wednesday or Friday, my lord. It's regarding non-payment of contractual bill.
That will be next Friday, my lord.
Friday, my lord. One week, my lord. My lord.
Oh, my lord can fix a date, my lord. 17th.
Item 25 and 26.
Lordship, as per order dated 8/1/2024, respondent is supposed to submit the inquiry report in seal cover before this honorable court.
Seal cover. 25. Sohidul Islam. Yes.
You are going,
according to last
you
order,
no
Lordship.
longer look into the last orders.
Yes, Lordship.
before taking the
According to
responsibility.
last. Yes, Lordship. Hearing should be conducted in the presence of both the parties, and that hearing is also held. And the findings of this outcome I have received.
Oh, you have the inquiry report?
Yes, yes.
Then why were you looking so confused?
No, I think some other inquiry. Seal cover is I have not. It is not in seal cover.
The report is adverse. I think you file it by way of an affidavit.
Yes. No, this is not. It is latest report 3/5 on 3rd May. It has received.
Correct. So you file it.
No. Yeah, we have to file affidavit.
That is what I am saying. You
Yes.
file it by way of an affidavit.
Yes,
Ms.
yes.
Baruah. Any difficulty in understanding today? Let this instruction be clear, because it appears the findings are adverse to your interest.
Yes.
So you will get a right to rebut. MS.S. Borwa, learned government advocate for the state respondent, has placed the hearing report received by the office of the junior government advocate by letter dated 3/5/2024 in terms of the order dated 5/4/2024 passed by this court. Stop. Let the same be placed by way of an affidavit with an advance copy to the other side. Stop. List this matter after
2 weeks, Lordship.
After 2 weeks on a date to be fixed by the registry.
Obliged.
The copy of the instruction dated 3/5/2024 is accordingly returned to MS.S. Borwa.
Item 27.
May I please?
25/26. 25/26. Yes, Mr. Majumdar.
My lord, there are three petitioners in this petition. My lord, they are all allottees of fair price shops, my lord.
No affidavits have been filed in
My
this
lord,
matter.
Yes, instruction
Instructions
received,
were received.
Lordship. Sometime required to file affidavit, Lordship.
On the last occasion also the same prayer was made.
But I'll just point out one thing, my lord. Based on the instructions received, a connected matter had been disposed of by this honorable court on the last occasion. This matter was also about to be disposed of. Paucity of time did not allow that to happen. And if the instructions remain the same in both the cases,
Where is that
the
order?
other order, my lord, Lordship, would like to take this one. The issue here was, my lord, that we have been given the shops, we have not been given the e-point of sales machines and the identities.
same cause of action. Without that, it is difficult for us to make the sales. So Lordship would find at para 3 onwards, my lord.
Yes.
Accordingly, the para 2 element, the case of the petitioner is that they are dealers of the fair price shop in their respective village under the so-and-so GPSS. The government of Assam introduced distribution of essential commodities in online mode by issuing EPOS device for which the individual dealer identity is required. My lord?
EPOS device?
My lord, those machines where you insert the card and they make the this thing, that those machines are called electronic point of sale machines.
All right.
So now every consumer has a electronic card. He inserts it. Whatever is due to him,
It is reflected.
it is reflected. They disburse it, and the payment summary.
This is for accountability.
Accountability. So others cannot do it. It is done by thumbprints.
All right.
It runs with thumbprints. Accordingly, the petitioners claim that they have approached the Assistant Director of Food and Civil Supplies and Consumer Affairs for providing them with dealer identities. It is also projected that after various fair price shop dealers have either resigned or started procuring food articles from other GPSs, vacant identities of erstwhile dealers are available. Therefore, the petitioners have approached the Assistant Director of Food and Civil Supplies to upload the names of the petitioners against those identities of erstwhile dealers. However, approval has not been received and apprehension is expressed that the supplies of commodities for distribution under PDS system may be stopped to the petitioners. In this case, although notice of motion was issued by order dated 26/6/2023, but no response has been filed till date. The Learned Standing Counsel for the BTC has submitted that he is in receipt of instruction via letter dated 1/8/2023 in connection with the issues raised in this petition, and he is instructed that the Council Head of the Department of Food, Civil Supplies and Consumer Affairs, BTR Kokrajhar, on consideration of the matters available on record, issued letter number so-and-so to the Director of Food and Civil Supplies and Consumer Affairs to create new fair price shop dealer identity, and the matter relating to creation of new identities under consideration of the Director, Food and Civil Supplies and Consumer Affairs, Assam. From the said instruction, it also appears that the state government has already issued direction to the Principal Secretary BTC to take action against the fair price shop dealers who have been found violating the notification for online delivery of NFSA commodities without using EPOS device. Under the circumstances, it is seen that the authorities in the BTC have no objection to the petitioners being granted new identities to enable them to supply NFSA articles through
So
EPOS.
this is also a case where you are seeking the
Identity
direction for making the EPOS device available to you.
By
This
giving
is
us
what
an
you are-
identity number.
By giving you the identity
Number.
number.
Otherwise, we are
And
dealing with it.
What is your instruction?
Same instruction.
Same instruction. Then we will pass the same order.
Yes.
What is the instruction dated?
Same
25/4/2022.
No, it's at para 5, 1/8/2023.
So same date.
Same date.
Then the same, exactly the same order can be passed.
But there's
Everything
just
is same.
One difference I have to point out. Here, my lord, for this petition, the applications were already forwarded to the Director of Food and Civil Supplies, Assam. In this particular case, it has not yet been forwarded. They have only forwarded the online copy, is what we were told.
No, in the case in hand, it has already been forwarded.
It has been. It is to be forwarded to the Director of Civil.
Where that touches.
He says it is forwarded, my lord, and I have nothing. In filing of the petition, I had an impression that it was yet to be
So then
forwarded.
the same order.
Same order.
All right, Dorothy, you pass the same order. খালি লোকৰ হেৰিখিনি লৈ লওক।
Intern order to কেতিয়া আছিলে?
কিন্তু নামখিনি দি দিব।
Intern order date কেতিয়া আছিলে?
Same order দি দিব।
কেতিয়া হ'ব ন? কেতিয়া?
Earlier there was an interim order.
My lord, yes, but
That is
on
dated?
26, same date, my lord. But on the last occasion, what happened is when this matter was disposed of and the other matter remained
It
due
was
to
not
consideration,
extended.
that extension did
So
not.
then that part is not
My
required.
lord, but the 26/6/2023, if not given, the protection is not given. In the meantime, again, they may take a cancellation. We have informed the other court, my lord, that
All right, so we will include that also.
That part of
দি দিব, একে order.
I'm deeply obliged.
Disposed of.
I'm obliged.
Settlement Act. Lordship? Yes, along with interest under MSME Act, they were supposed to file an affidavit, which has nothing has been filed.
But it is the PAC department will have to file it. PAC department will have to file it.
He was very much here. So let them file their affidavit.
There is 32 to execute.
Mr. Borthakur, who's appearing?
32 is also, so what?
Mr. I. Borthakur appears?
Well, D. Gogoi will appear, my lord. He is on Diggs, my lord.
32.
So are you filing your affidavit?
Perhaps he is appearing.
Yes, you address the court. What about the affidavit? When are you going to file?
Sir, we'll file it, my lord, within 2 weeks, my lord. Within 2 weeks, we'll file it, my lord. Perhaps I'm not
Within?
appearing 2 weeks.
What
my
is
lord.
perhaps?
Well, I have to take instruction from him also, my lord.
From whom?
You appear now in most of the cases.
I'm just.
Yes, Mr. Pathak, please assist the court. Are you filing any affidavit or should we hear Mrs. Hazarika and dispose
Lordship,
of
I
this
have the matter,
petition?
have the matter after 5 minutes. I'll just ask my colleague who is handling the matter to appear.
All right. 5 minutes.
Yes, Your Lord. I'll just advise. I'll just walk with you.
This item 28 is connected till 32. All right. Thirty-three at the Yes.
34. Yes, Lordship. Lordship, 438 bill application.
Case diary is available.
34 minutes. One second. 34 case diary is not received.
Await case diary. Interim order passed earlier shall continue till the next date. List on
30th of May. 30th.
List on
35/24.
35/2024.
Obliged. 35 case there is there, you know.
Was the petitioner on interim?
Yes,
Yes.
Have
on
they
interim,
appeared?
He has
Statements
appeared.
recorded?
He has appeared. Statements recorded.
Anything, Mr. Das?
My lord.
Anything?
Lord, he has cooperated.
Cooperated?
Otherwise, yes. Otherwise, case is serious, my lord. That's all.
FIR is at page?
Page 13.
Page?
13.
Shareholders. All right.
Shareholder.
Since they are cooperating.
As per his statements, my lord, whatever he has been done under instruction of his brother, my lord, the Lutfur.
Under instruction of?
Lutfur is his brother, not main accused.
You say that when I read. Heard MS?
A. Hussain.
MS A. Hussain, learned counsel for the petitioner, stopped. Also heard Mr. D. Das, learned APP for the state, respondent, stopped. This is an application under section 438 of CRPC 1973 for granting pre-arrest bail to the accused petitioner, i.e. S.H. Sohidur Rahman, who is apprehending arrest in connection with Mankachar PS case number 431 of 2023, registered under sections 403, 406, 409, 468, 34 of IPC. Stop. The case diary called for is placed before this court. Stop. The case of the prosecution is that the petitioner had misappropriated an amount of rupees 22,35,972 of the shareholder of Kalapani Samabbai Samiti Limited during the period of 2017 to 18 while he was holding the post of acting secretary of the society. Stop. Next paragraph. Pertinent that by order dated 7/3/2024, the petitioner was granted interim pre-arrest bail subject to conditions thereof by order dated 7/3/2024. Stop. Mr. D. Das, learned APP for the state respondent, submits that the petitioner has appeared before the investigating officer in terms of the pre-interim arrest order date passed earlier by this court. Stop. He further submits that the statement of the petitioner has been recorded under section 161 CRPC. Stop. He further submits that the petitioner is cooperating with the investigation. Stop. Heard parties and perused the records available. Stop. It appears from the records that the petitioner is cooperating with the investigation, and the statement of the petitioner under section 161 CRPC has already been recorded. Stop. It further appears from the statement of the petitioner that he has...
That may not be recorded. After all...
It further appears that there are no adverse materials available on record against the antecedent of the petitioner. Stop. Accordingly, this court is of the considered opinion that custodial interrogation of the petitioner may not be necessary for the ongoing investigation. Stop. As such, the interim pre-arrest bail granted earlier by this court by order dated 7/3/2024 is hereby made absolute, subject, of course, to the following conditions. 1, 2, 3, disposed of. No, call the other matter.
38.
Mrs. Hazarika's matter.
36.
28 to 32.
Just a minute, Mr. Das.
I'm sorry, my lord, I was in court 4.
Yes. Are you filing a rejoinder in this an affidavit in opposition?
Curiously, my lord, I had come across an order passed by your lordships. My lord, they are claiming interest.
No, please.
An MSME. My lord, kindly.
What is this, Mr.
No,
Gupta,
my lord, the petitioner's farm...
Have you given a copy to
yes,
the
sir,
other
I can
side?
give, my lord. No. Petitioner's farm claimed to be MSME license holders, and they were given works under PHC department. My lord, they filed a claim for non-payment.
You are trying to say that this case is covered by this?
Yes, my lord.
Let Ms. Hazarika have a look at it.
Yes, so Lordship, before he comes to that, in the first case, I am challenging an order which has been passed by the engineer, chief engineer. I have come against that order, so that is not covered by this. The legality and validity of the chief engineer's order.
Now,
so let them not take
now,
us.
Lordship,
let me make one thing very clear to you. If you want, you can file your affidavit in opposition.
My lord.
If you do not wish to, then this court will take up this matter for hearing. Later on, do not say that you want time for filing an affidavit in opposition. I am making it very clear. Because the senior counsel says this case is not covered, so we will have to hear.
In that case, I'll file affidavit, my lord, but I'll confine my affidavit to maintain.
Whatever
my lord.
Whatever you want to do, whatever.
Discretion.
Yes,
The court cannot dictate you
yes.
what you will file, but whatever you file, thereafter this court is going to take this matter for hearing.
My lord.
So whatever consequences, that you will bear.
My lord.
When do you want it? Give us a firm date. Why are you all looking at each other? Why
My lords,
can't you all
my lords, one has to draft it and this has to go and come back. It requires a time. I'll spell out a date. It won't come. I'll be on the receiving end again. Let it be in June, my lords. Let it be in the month of June.
No. Not so much time. 2 weeks.
2 weeks, my lords, a fixed date, my lords.
Mr. D. Gogoi, Learned Standing Counsel, PHC Department, takes 2 weeks' time to file affidavit in opposition matter. Stop. He further submits a copy of the order dated 26/2/2024, passed in WPC 5029 of 2021, stating that the said judgment in order squarely covers the case in hand.
My lord.
Stop. However, M. Hazarika and a senior counsel assisted by so-and-so disputes the same. Stop. Be that as it may, let the affidavit in opposition be filed within a period of 2 weeks from today. Pursuant thereof, the matter shall be taken up for admission hearing. List after 2 weeks.
Lordship, if the date is fixed.
All right. 2 weeks after the date of the date. List on so-and-so date. And then add one more thing, that considering that the issue involved in this subject matter pertains to 2019, pertains to the year.
Yes. Lordship, this is for a long time. 15 said they have not been paying us.
Well, this is second on which
Considering the fact that the dues of the petitioner is not being paid for since
decades, at least a decade.
For a long time, it is needless to clarify that the affidavit in opposition shall be positively filed by the next date.
Perhaps, my lord,
In the failure of non-filing of the affidavit by the next date, this petition shall be proceeded in accordance with law.
My lord, perhaps that view, my lord, will keep as tentative because their principal amount had been paid. We are disputing the
All
interest
right,
part, my lord.
next.
Again, a wrong statement, Lordship. Please
Next
ask
matter,
them.
please.
Don't make wrong statements all the time. We learn.
May I please? CD was called for. It is why the interim bail, my lord, was appeared before the
38 and 40 minutes, same case there.
38
and 40.
Is there?
Same case there.
You have the case there?
Yes, yes. Well, in this case, my lord, item number 38, the petitioner has been granted in interim bail. But in 40, his prayer was rejected earlier.
First, you concentrate in item 38.
38, yes.
Yes.
Well, his statements are not available in the case there, so updated case there will be required.
It's not there.
Not there.
When can you have it?
Well, this is a case from Nalbari, 10 days time.
Do you already have an interim?
Yes.
Await case diary. List this matter on
Updated case diary. I may be permitted to return it below.
up to date case diary. Okay? List this matter on. Yes, give a date after 1 week.
May 30.
35, 2024. Interim order passed earlier shall continue till the next day. And in item 40 also, I think the same case diary has not come.
Yes, but he is not on interim below.
Media await up-to-date case diary list on.
Madam, may I pray, Lordship, I will be cooperating with the investigation. I may be allowed to appear before the IO, Lordship.
May I submit one thing, Lord?
By now, this updated case diary was called on 9th of April.
Yes, we sent.
But till it is taking so much time.
No, my lord, one thing.
Otherwise, we will grant interim bail.
Actually, case diary is lying here. On 21st of.
Very well, let the petitioner appear.
Yes, this Conjit may be allowed to appear. For item of 40, he may be allowed to appear.
In item 40, that heard MST Som, learned counsel for the petitioner, also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 438 of CRPC for granting pre-arrest bail to the petitioner, i.e. Conjit Kolita, who is apprehending arrest in connection with Nalbari PS case number 32 of 2024, registered under section 120 within bracket B, stroke 143, stroke 144, stroke 341, 326, 307, 436, 353, 427 of the IPC. Stop. No updated case diary was called for by order dated 9/4/2024, the same has not been furnished to the court today when the matter has been called. Stop. Let call for updated case diary fixing the matter on
30 May.
35/2024. Stop. Considering the facts and circumstances of the case, in the interim, it is provided that in the event of arrest, the petitioner named above, shall be released on interim pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority, subject to, of course, to the following conditions. 1, 2, 3, First condition, 10 days appearance before the investigating officer. A to A case to test. My green flag marriage. And I can.
Deeply obliged, Deeply obliged.
list accordingly with DD Balaji. Yes.
May I please, Your Lord?
Yes.
My Lord, with all respect, my Lord.
Case there is there.
Yes.
Here, my Lord, so far as the FIR is concerned, my Lord, it is regarding robbery of some amount of gold, my Lord. 4 persons are named in the FIR, my Lord, and all 4 were arrested. That would be apparent if I read page 22, subsequent to the FIR, my
You are
Lord.
not named in the FIR?
No, not at all, my Lord. So I'll tell my story, my Lord. With all respect, my Lord, but kindly have a look at page 22, my Lord.
Yes.
Page 22, my Lord. There it is stated, my Lord. It would be, I'm sorry, my Lord, page 23, my Lord. Will you hear? 23, my Lord. There, my Lord, last paragraph, my Lord, with all respect, my Lord. All 3 arrested accused persons have revealed that in a group, FIR names 4 persons, my Lord. Yes, my Lord.
This is forwarding.
My Lord, the bail application, page 23, my Lord. Yes, my Lord. Annexure 4, my Lord. May I read it, my Lord? The last paragraph, chronologically 8, my Lord. 8, my Lord. All 3 arrested accused persons have revealed that in a group of 4, they kidnapped the complainant when he was standing in front of Dream City Hotel near ISBT and looted from him 2 packets of gold biscuits containing No, not at all, my Lord. Exactly, my Lord, that 4 have been arrested, and one line in para 8 is very important, my Lord. Now, my Lord, with all respect, my Lord, biscuits containing 12 pieces of gold which they handed over to the 4th associate accused. They called Bhini. Now Bhini is absconding. Subsequently, Bhini was also arrested, meaning thereby 4 persons looted. The gold was given to Bhini. Yes, my Lord. This is the forwarding report, my Lord. And Bhini's bail order we have given, my Lord. Yes, my Lord. At that point of time, one was absconding, my Lord, to whom gold was given, my Lord. Now, my Lord, these are... May I just place it, my Lord?
My Lord, yes, 4 persons were arrested. My Lord, initially 3 persons were arrested. One was absconding for some time. Against this.
My Lord.
Everything, my Lord, but after arresting the 4th person who was absconding for some time, he says that after committing the offence, they called him to a dhaba at Sonapur, and for the purpose of selling it to him. The allegation against him is, my Lord, he purchased it at 5 lakhs rupees as well as.
My Lord.
But my objection will be recorded, my Lord. It's a serious offence. Otherwise, no, my Lord. Sensational case, my Lord. Daytime robbery, my Lord. He is. No. Only, my Lord, some melted golds were, my Lord, seized from him, his house. My Lord. Yes, that is correct, my Lord. That is a matter of record, my Lord, whatever I have stated.
Page 12, my lord. My lord. My lord.
Submits that the four accused persons involved in the offence alleged has already been arrested.
My lord.
He further submits that it appears from the grounds of arrest that the three arrested accused persons have revealed that they, along with one another, who also is subsequently arrested,
My lord.
was involved in the
My lord. Yes.
Mr. Vikas, when at APT, was the state respondent on the other two subjects that upon the fourth accused being arrested and during his interrogation, it has come to light that they were supposed to meet the petitioner for selling the stolen.
My lord.
Heard the submissions made at the bar and produced the witnesses available. It appears that investigation has substantially progressed and the accused involved in the offence alleged has already been apprehended by the investigating officer. It further appears that there are no incriminating materials as regards the antecedents of the petitioner available in the case diary.
My lord.
Stop. Further, considering the entire facts and circumstances of the case, it is considered opinion of this court that custodial interrogation of the petitioner may not be necessary for the ongoing investigation. Accordingly, it is provided that the petitioner named above in the event of arrest in connection with the subject of the case, which has been released on furnishing bail bond of rupees
50,000? 50,000?
50,000 satisfaction of the arresting of
My lord.
subject, of course, to be forfeited.
My lord.
Here,
My lord.
10 days.
My lord. My lord.
10 days,
One minor correction, my lord. As per that statement of the fourth accused, he says, my lord, he sold it at rupees 5 lakhs to him. Not supposed to sell. Gold. To the petitioner at rupees 5 lakhs. 5 lakhs.
Highly obliged. Obliged.
Item 42.
Return. Oh, কি মানে টু
40.
40
42.
42
Scan.
huh scan copy আছে
Such techniques.
42 minute sorry this is scan copy I think I could not go through it minute scan copy, it doesn't appear in the cause list, perhaps not come. Reminder.
이 말에 মনোযোগ নাই তাৰ কামত গুৰুত্বলৈকে ভাবি থকা নাই 42, 44, 45, 46, 47, 47.
After 2 weeks, on 28th of May.
28.
Timing item 13.
I am appearing for the bank here, Your Lordship. At that point, the issue in a nutshell is, Your Lordship, that the petitioner participated in an auction under the SAPESI Act. He was the successful bidder. The sale certificate was issued in his favor. Now we sold the property on an as-is, where-is basis. So the property of the description of the property was 2 bighas, 3 kathas, 9 lachas. And when the petitioner went and applied for sale permission, the revenue authorities objected on the ground that no, the actual measurement of the property is somewhat lesser. Now the auction conditions mandated that he had to exercise his own due diligence, and that auction process is now concluded. So his prayers, I think the petitioners, there was a prayer from the petitioners. Very well. I'm appearing not as not a standing counsel, I'm appearing on Vakalat now for the response number 4, Your Lordship. Very well. Deeply.
Item 43.
No, Lordship. It's 16 meter, my lord.
Yes, Lordship. After a long time. Yes. No, in fact. Yes. I mean, in fact, today it has 20. Almost. Can it be, Lordship, next week? Lordship. Yes, sir. Dominate, okay. Uh, 1 week.
49, 46, 47, 48, 49. मिली उसे सर
আপনার 32
अच्छा Double vote. 33. Oh, people mentioned it. The most for it. Mentions. I play there.
Babu, where is that? Thank you, mention was it. Mention
18 পাবা হা 18 18 আপনারা তাই 53 লেখা পেন রাখতে পারেন Item number 18, fixed at 2.
Lordship, in this case we have received one instruction, Lordship. In this case we have received one instruction.
You have received instructions?
Yes. So it seems, Lordship, already a speaking order has been passed, whereby his phrase application for the arm license has been rejected, Lordship. So he has to change that order if he has any grievance, Lordship.
Can you obtain instruction?
Lordship, with regard to this, Your Lordship, if Your Lordship peruse this court's last order, Your Lordship, it was held that there is a subsequent application which has been filed under the provisions of the Assam Arms Rules 1962. And Rule 25 states that if there is an arms of a member of a family, then that arms may be transferred to the legal
Then
hand.
you do one thing, Mr. Porwa.
The indication is there in the instruction.
Why don't you file an affidavit placing this instruction on record? Let them file a reply if need be so, and then this court will take up this matter.
And Your Lordship, also Your Lordship, as per the order of 1/3/2024, Your Lordship, it was held that even while filing the affidavit, the subsequent additional affidavit will also be considered, Your Lordship. And
Yes, it was already directed
Yes,
that Mr. Bora shall obtain instructions with regard to the aforesaid application and place the same by way of an affidavit. Now they have already obtained instruction.
Yes, sir.
So let this be placed by way of an affidavit.
Yes, sir. This instruction is with regard to the file number KAA3/2018/15.
This is not the required information according to you.
Your Lordship, I have
two applications were there.
No, Your Lordship, actually 3 applications. 2 applications were earlier filed, Your Lordship. 1 application has been rejected as per the instruction. There is another application which is arm license file number 15/27/7/2020. Thereafter, Your Lordship, another application has been filed under Rule 25 of Assam Rules 1961. So that has not been placed.
All right. That Mr. S.R. Borwa, learned junior government advocate, submits the instruction received by the letter dated
14/3/2024.
14/3/2024. Why these dates are kept at the bottom? It should be on the top.
It's
14/3/2024. Top. Mr. I. Hussain, Learned Counsel for the petitioner, submits that the aforesaid instruction does not address as regards the status of all the other two applications filed by the petitioner in respect of the arms license, subject arms license. Stop. Let a detailed affidavit be filed within a period of 2 weeks from today, addressing the status of the 3 applications filed by the petitioner for obtaining arms license. Stop. List after 3 weeks on a date to be fixed by the registry.
Item number 33.
Lordship, in this case, Lordship, we are appearing for response number 2, 3 and 4, item 33, but we are not served with the copy, Lordship, as well main copy as well as the extra copy. I have checked the record also, Lordship.
You have not served the extra copies? Let extra copies be furnished to the government councils, respective government to the government councils representing the respondents. Stop. List along with. This is related to the same matter.
It's related to
List
Assam
after 3 weeks on a date to be fixed by the registry.
Item 46.
Victim compensation.
Yes, my lord. The award already passed by the DLSA, my lord, but the DLSA.
For respondent number 5.
I apologize. My name was not reflected in the cause list. I am appearing for the respondent number 5.
However, I could not get the requisite
So therefore,
instructions.
service in respect of R5 stands completed.
Completed, yes, Your
All right, and you wish to file some affidavit?
Lordships, I can place the requisite instruction before Your Lordships. What has happened is that in the last 1.5 years, no amount of compensation has been granted from the state government side to the Assam State Legal Service Authority. In that context, a PIL has also been filed before the Honorable Chief Justice, wherein the Honorable Chief Justice has taken up session of the matter, and the matter is now fixed on 20th of May, which is the order which I was trying to place before Your Lordships.
In this petition, what is under challenge?
It's not
And
under
you are
challenge. The
appearing
fact
on
is
behalf of-
that a quantum of compensation has been granted to the petitioner. However, that has not been released due to paucity of funds.
Appearing for?
Respondent number 5, Your Lordships, the Assam State Legal Service Authority.
But you are appearing for the legal service?
Yes,
authority.
yes.
Then, Ms. Chaudhary, we shall record that the R5 service is completed and post this matter on another date.
As Your Lordship.
And by then, if you wish, you can file your affidavit.
I could do that.
Because that PIL is pending.
The PIL is pending for consideration. It's fixed on 20th of May, Your Lordships, for further
Fix
business.
this matter after 28th May?
Lordships, could you keep it after 2 weeks?
It appears from, not say it, that MS.R. Chaudhary,
R.S.
Chaudhary, Learned Counsel for the respondent number 5, entered appearance on behalf of respondent number 5. Stop. Accordingly, service in respect of respondent number 5 stands completed. Stop.
Sorry, I took the whole slip.
MS R.S. Chaudhary further submits that there is a PIL pending before the division bench of this court in relation to victim compensation.
Release of funds under the victim compensation scheme.
In relation to release of victim compensation fund under the scheme. Stop. He further submits that the said PIL is scheduled to be listed on
20th of May 2024.
28/5/2024. Stop. List this matter after 2 weeks on a date to be fixed by the registry. Stop. In the meantime, respondents may file affidavit in opposition, if they so desire.
Not just my name may kindly be reflected in the cause list. The registry may be directed to.
Further, let the name of the Learned Counsel appearing on behalf of respondent number 5 be reflected in the cause list.
Deeply obliged.
Okay.
As per office note, we have taken steps to the respondent number 1 today itself.
Today?
Today. We have taken already.
Mr. M.U. Mondal, Learned Counsel for the writ petitioner, submits that steps in respect of respondents.
Number 1.
Respondent number 1 has been taken today. Stop. Let registry verify and place up-to-date report in this matter. Stop. List this matter after 2 weeks on a date to be fixed by the registry. Okay, sir.
Item 48.
Steps.
My lord, we have
Steps taken or not taken?
in the earlier occasion we have taken steps, my lord.
Earlier occasion?
But
The
subsequent.
last order of the office notes indicates no such steps have been received.
My lord, we have taken steps, my lord.
You are not aware?
My lord, in respect of respondent number 5, my lord.
Yes. Anyone appearing for respondent number 5?
My lord, actually the respondent number 5 is represented by the government, my lord.
Who is R5?
Chairman, District Legal Services. Chairman,
Mr. Counsel, are you going to take fresh steps or not?
Yes, my lord.
Otherwise, I am dismissing it.
Allowed to
Because there is a
take
judicial
process.
order for taking steps and you have not taken it.
Allowed to take process.
Mr.
M. Hussain.
M. Hussain, Learned Counsel for the petitioner, assures that the fresh steps as required to be taken upon respondent number 5 shall be taken within a period of 3 days from today. Stop. In view of the aforesaid assurance made by the learned counsel for the petitioner, list this matter after 3 weeks on a date to be fixed by the registry. Stop.
Obliged.
Item 49.
May I please, Lordship?
Yes.
Lordship,
What is this IA?
IA for Lordship, extension of time for appearing of the petitioner, Lordship. In compliance, Lordship, in compliance of Honorable High Court Order, Lordship 6/3/2024, passed in AB, Lordship, with
Where
direction.
is the APP? State. Can you inform one of the APPs to be present? Wait for some time.
Item 50.
Yes, Mr. Kejriwal, what is this IA? Mr. Majumdar, are you appearing in this matter? Yes.
This IA is filed, Milord, praying for amendment of
You
the
were
relief.
supposed to file an objection, Mr.
Objection was,
Majumdar.
affidavit was prepared, somehow we couldn't be filed, is
How
ready in the
much time
file.
would you require?
1 week time will be enough. My affidavit is ready, madam.
Mr. D. Majumdar, learned senior counsel representing the state respondent, you're appearing here as learned additional advocate general for the state respondent, submits that that his office has received the necessary instructions for filing the objection to the prayer made in the connected interlocutory application. Stop. Mr. S.K. Kejriwal, learned counsel for the petitioner, does not object to the said prayer. Stop. List after 2 weeks on a date to be fixed by the registry. In that first paragraph, you see, and accordingly he seeks 2 weeks time for filing. Itu bhorai diba, মই চাই দিম.
Item 51.
May I please, Your Lordship?
Substitution
Lordship. Father of the petition.
coming up for the first time.
Lordship. Father of the petition.
I don't have any objection, although, my lord, the petitioner expired 1 year ago, and there is no explanation. In spite of that, my lord, I do not like to...
You are
file.
appearing for all the
All the
respondents, Mr.
respondents.
Sharma.
Yes, my lord.
You want substitution of?
Petitioner.
Yes, but who is going to be substituted by?
His son, Lordship, Anand Kumar Pandey, Lordship.
He is the acting Karta.
Lordship.
All right. Now dispose it off, Mr. Sharma.
Yes, my lord.
In item number
51, Lordship.
Heard, Mr.
N.K. Sharma.
N.K.
Sharma, Lordship.
Sharma, learned counsel for the petitioner. Stop. Also heard Mr. D. Sharma. D.K. Sharma, right? Mr. D.K. Sharma, learned counsel
Order, my lord, I was here.
for the respondents.
Respondents.
Stop.
6 to 9.
6 and 7 I am appearing.
Then you say for the respondent within bracket IOCL. And Mr. S.R. Borua,
respondent number 6 and 7.
advocate for the state respondent. Expired. This is an application for substituting the name of the applicant in place of the official representative of the petitioner within bracket MS Bhubaneswar Pandey and Rameshwar Pandey. Why MS?
Lordship. MS.
No, my lord,
It's a partnership firm.
this is the name of the firm.
Acha, acha.
The
Okay.
substitution is short for
Brajendra
against
Pandey.
Sri Brajendra Pandey.
In WPC number 5756 of 2020 within bracket MS Bhubaneswar Pandey and Rameshwar Pandey versus Oil India Corporation Limited and others. Stop.
Indian Oil Corporation.
Why it's not? It's written incorrectly in your cost title, Indian Oil Corporation. The facts of the case is that the applicant, who is the acting Karta of the petitioner, i.e. Messrs. Bhubaneswar Pandey and Rameshwar Pandey, upon the death of the earlier Karta, i.e. Brajendra Pandey, has filed the instant application for bringing for substitution of his name in the place of the earlier deceased official representative to carry out the litigation in the present case. Stop. Heard the parties and perused the averments made in the interlocutory application. Stop. It appears that since the earlier Karta died on 17/4/2023, who was representing the joint Hindu undivided family of the petitioner concerned, the prayer for substitution is required to be granted in the interest of justice. Stop. Accordingly, it is directed that the name of the applicant be substituted in the cause title of the application in place of the official representative Karta of the petitioner in WPC number 5756 of 2020. I accordingly stands allowed. Any amended cause title is required to be given?
Now it is necessary to amend the cause title. Lordship may give us the liberty to...
Let the amended cause title be submitted before the registry of this court for doing the needful.
Nowadays it is required.
That is why I disposed of.
Lordship may fixed a writ petition.
In the writ petition you say, in view of the aforesaid order passed in IA number so and so, list this matter after 1 week on a date to be fixed by the registry.
In this matter, interim order is there.
Interim order, if any, shall continue till the next date.
Item 52.
May I please, Your Lordship?
Yes.
During the main pendency of the main petition, Your Lordship, respondent number 3, respondent number 4 and respondent number 8 died, Your Lordship.
May I please, Your Lordship? Yesterday I have received the petition IA, 3 IA, and kindly allow me 3 weeks time for taking necessary
it has come?
Instruction for filing objection.
We'll issue notice and give you that time. This come for the first time.
First time.
Unique on IAS. There are 3 IAs.
3 IAs, Your Lordship. One is substitution.
1310, 3755 and 3756.
Yes, Your Lordship.
In all the 3 IAs, notice is required.
Notice is because already all parties have appeared, Your Lordship.
No, formal notice may not be required. All right.
Yes, all right.
You are appearing for the respondent?
Respondent 3 to respondent 10.
Yes, everyone is
and
appearing.
3 weeks time for filing objection.
Respondent 3?
Yeah.
Who is appearing for the municipality board?
One I am appearing.
Okay. That heard your name, M.S.G. Bora, Learned Counsel for the petitioner. Stop. Also heard M.S. M. Bhattacharjee for respondent number 3
to 10
and 3 to 10, and Mr. S.R. Borwa, learned government advocate for the state respondent.
For one, respondent number 1.
Then what about the municipality board?
The notice will go, they will engage their own counsel.
To be government advocate for R1 corridor. Then you say, this is an application under Order 22, Rule 9, of CPC for setting aside an abatement order dated 17/4/2023 against the respondent number 3. Stop. Issue notice, returnable 2 weeks. MS M. Bhattacharjee accepts notice on behalf of respondent number 3 to 10. Stop. Mr. S.R. Borwa, London GA, accepts notice on behalf of respondent number 1. Extra copies within the course of the day. Registered post AD in respect of respondent number 2 within a period of 2 days from today. 3 days. But 3 days, tomorrow is a holiday?
Yes, tomorrow is a holiday.
Then you say 4 days. List after Kiman week koilo returnable 2 weeks. List after 2 weeks on a date to be fixed by the registry. The other IA is also same.
No, the other IA, Your Lordship, there is some delays, Your Lordship. So Section 5 Limitation Act is there, Your Lordship.
Then A to Potham to
It has to be hard
1310.
first, Your Lordship.
Okay. Now.
And one is substitution petition, Your Lordship.
3755.
I have some objections, so kindly allow me 3 weeks time for filing objection.
In which one?
Actually, 3 IA.
No, we have already given, you file whatever you want to file within 2 weeks. In the
Actually, in delay petition also I have some objection.
3755. MS M. Bhattacharjee, Learned Counsel, appearing on behalf of respondent number 3 to. Here you are appearing for 3 to
10.
10, 6. 2 weeks time to file objection. Stop. Prayer allowed. List after 2 weeks on a date to be fixed by the registry. But in this also, chairman is there. Notice has to go. Notice has not gone till now.
We have accepted the formal notice, but
Correct.
it has to be voted on.
Rima, delete that order, the second order, and you write like this. Hey, upara portion khini eki likhiba. Tar pisot lekha that this is an application for condoning the delay of 123 days to set aside an abatement order against the respondent number 3. But unless this delay is condoned, can the other IAs be taken?
First, delay condon have to be hard, Your Lordship.
So then, councillors, you all are not assisting the court.
Yes, Lordship. Lordship, Section 5
If the
limitation.
delay condonation application is pending, then first notice has to go in this.
Yes,
Correct. Then the other in the other IAs, no order is required.
Yes, 3755 will be
Is the delay
first
condonation?
Delay
Me
condonation,
agor
Your
guti order to cut it there. Earlier IA to. IA 1310 delete kore dia and IA 3755 to lekha. সেই প্ৰথম তেওঁলোকৰ appearance লিখিলা and then you say this is an application to likhila for condoning the delay of 123 days to set aside an abatement order as against the respondent number 3.
And 178 days, Your Lordship.
Condone the delay of 178 days to set aside the abatement order as against respondent number 4 and to condone the delay. I have not understood. How come you have filed one application where you are seeking 3 condonation?
Because all of the parties in the same suit, Your Lordship. Same
That is another thing, but there are 3 different appeals that you have, 3 different...
3 different parties, Your Lordship.
Correct.
3 different respondents, Your
Then,
Lordship.
how is this maintainable? I think you should withdraw and file 3 separate applications. I have doubt.
Give me 3 or 4 days time, Your Lordship, so that I can clarify that stand,
I'm
Your
posting
Lordship.
it on Monday. You look into it. I don't think this application is maintainable in the present form.
No, something fix the matter on Monday, Lordship, kindly, Lordship. I'll.
Why there are three different dates for condoning?
One is like three different dates they died, Your Lordship. So, Your Lordship, the condonation will be there like this, Your Lordship.
I think three separate application has to be filed.
Let me clarify that stand, Your Lordship, on Monday, Your Lordship, kindly.
Listen, simply in item 52, গোটেইকেইটাতে একেলগে এটা অর্ডার দি দিবা লিস্ট অন মানডে affidavit filed.
My lord, we have filed affidavit today to bring on the dusty service upon respondent 2 and 4.
All right. Mr. B. Borwa, Learned Counsel for the petitioner, submits that an affidavit of service has been filed today, however the same is not placed on record, available on record. However, the same is not available on record. Stop. Let registry verify and place the same on record. List on?
After 2 weeks.
After 2 weeks on a date to be fixed by the registry.
I have received extra copies for respondent number 3.
In the meantime, extra copies as directed earlier be furnished to the learned counsels appearing for the respondents.
Obliged. Supplementary list, item number 55.
Lordship, steps taken to the respondent.
Yes.
Lordship, steps taken to the respondent number 1 and 2, Lordship.
Steps taken?
Yes, Lordship.
Your name?
M. Deka.
MS M. Deka, learned counsel for the petitioner, submits that.
And Lordship, on last date, CGC appear, respondent number 1 appear.
Submits that steps in respect of respondent numbers 1 and 2 has been taken. Who is number 2?
Lordship. Private respondent was
That nobody is appearing.
Yes, Lordship. Respondent number 2 has not appeared.
It appears from the office note dated 8/5/2024 that steps in respect of respondent number 2 has already been taken and delivered. Correct? It has been delivered? Stop. As such, service is completed in respect of respondent number 2. Stop. Where is Mr. S.S. Roy?
Lordship, he was there. Lordship, he has left the court, Lordship, due to some urgency.
And pose this matter
For admission hearing.
in view of completion of service, pose this matter for admission on any day, pose this matter after 1 week on a date to be fixed by the registry.
Item 58.
Why is this matter for orders today?
My Lordship, we have taken a step upon respondent number 5, my Lordship. Not come.
May I please, Your Lordship? I am appearing for respondent number 5. We have received the...
Oh, you have received?
Yes, then
MS?
P. Mishra, Your Lordship.
MS P. Mishra submits that she has filed necessary... You filed or not?
Yes.
MS P. Mishra, learned counsel for respondent number 4, submits that
Respondent number 5.
for 5?
5. Wrongly reflected in the course list.
Yes. For respondent number 5, entered appearance on behalf of respondent number 5. Stop. Accordingly, service in respect of R5 stands completed. And the other respondents, who is appearing? They are all represented?
Number 2 and 3.
1.
I am for 1 and 4. N Bora SCPLI.
4 weeks time may be granted, Your Lordship.
He further seeks 4 weeks time to file affidavit in opposition in the matter. Stop. Are you all joining with the prayer, or you all are waiting for the affidavit to be filed and then make a prayer? It is needless to clarify that the remaining respondents shall also file their affidavit in opposition, if need so. List this matter after 2 weeks on a date to be fixed by the registry.
My Lordship, fix in admission hearing, my Lordship. Admission hearing.
Let the pleadings be completed.
My Lord, 4 weeks time will be necessary.
3 weeks. 3 weeks koi di bari ma. Yes, Mr. Das.
My Lord. They pray for time to appear before the court.
7 days time was given.
7 days time was given.
Considering the gravity of the matter, what happened thereafter? They have not appeared.
They have appeared. The pursuant of my Lord, Your Lordship will kindly see some dates are important. My Lord may kindly come to page 12 of the petition, my Lord, IA.
Yes.
Last line, my Lord. Condition. The petitioner shall appear before the IO within 7 days from today and cooperate with the investigation. This is order dated 21/6/23. This interim order was passed in 21st of June 23. Now, my Lord, I beg to draw your Lordship's attention to page 10.
But this matter, why is it fixed before this court?
The bail, last order was passed by your Lordship. Yes, my Lord, page 9. Now, as per that interim order, my Lord, he was supposed to, my Lord, appear before the IO on or before 28th of June 2023. Now, he did not appear. Then, my Lord, your Lordship will come to page, my Lord, your Lordship's order. Relevant portion is page 10, my Lord. Second para, it is submitted by Mr. P. Bothakur. It is submitted by Mr. P. additional PP that charge sheet has been submitted in this case being CS number so and so dated 30/9/23. That means after 3 months, charge sheet was submitted from the date of granting pre-arrest bail to the petitioner. He did not appear. After that, your Lordship directed him to appear before the IO. Then also he did not appear.
Now, one thing, Mr. Das, on 6/3/24, I don't think it was submitted that earlier there was a direction. Otherwise, this case ought to have been before the other bench. Because it appears, this is...
It came for bail hearing.
Huh?
That is why it was no bar.
Order.
Final order.
Yes. No.
He was directed to appear. He should have appeared.
Lordship, I have Annexure 3, Lordship, page 14, Lordship. The petitioner's son's exam was going on during the time of Lordship from 6 February 2024 to 15 March, Lordship. As such,
Sorry.
That is after your Lordship's order. But what about interim order?
You cannot take this court for granted.
yes, Lordship.
This court has granted you you time, anticipatory bail. It needs to be respected. The conditions which have been imposed needs to be followed. If you have not followed it, nothing is to be done from this court. You are going to face the consequences. Sorry.
As last chance, Lordship.
No. In item 49, Lekha. Heard MS
P. Odhikari.
P. Odhikari, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. This is an application seeking extension of time for appearance of the applicant's petitioner in compliance of the Honorable Court's order dated 6/3/24, passed in AB case number 2203 of 2023. Petitioners petitioners I1, 2 আৰু তাৰ নামটো পেজ নম্বৰ 2 আৰু 3 পাবা. Stop. It is the case of the petitioner that because of the exam schedule of the sons of the petitioner number 1, the petitioners who are in relation brother and sister and are the only caretaker of both the son could not appear before the court within the time frame stipulated. Stop. Mr. D. Das, learned APP, opposes the prayer for extension. Stop. Third parties perused the averments made in the interlocutory application. Stop. It appears that by order dated 21/6/2023, the petitioner was directed in the interim to appear before the investigating officer within 7 days. However, the petitioner did not appear before the concerned IO. Stop. In the meantime, the charge sheet has been submitted vide CS number 116 of 2023 dated 30/9/2023 in connection with Kalgachia PS case number 8 of 2023. Stop. On 6/3/2024, in view of the fact that the charge sheet has been submitted, this court was pleased to direct the petitioner to appear before the learned Chief Judicial Magistrate Borpeta within 10 days from 21/3/2024 and seek regular bail, if so advised, and was further pleased to continue the interim order granted earlier by this court by order dated 21/6/2023. Stop. It is regrettable that despite expiry of 10 days granted by this court to the petitioner to appear before the learned CJM Borpeta, the petitioner failed to appear. Stop. Considering that the petitioners have been repeatedly violating the conditions granted by this court while considering the case of the petitioner for grant of anticipatory bail, this court is inclined to grant extension of time. Stop. Accordingly, the prayer for extension of period for appearance sought for in the instant interlocutory application stands dismissed. Stands rejected. Dismissed. এইটো কিমান নম্বৰ আছিলে
49
এই ডিসপোজাল কেইটা লিখি দিছে